And this week's topic is a lawsuit targeting the hiring practice of several Silicon Valley companies, including Apple, Google, Intel, and Adobe. What can you tell us about this lawsuit?
Well, in 2009, the U.S. Department of Justice launched an investigation into the employment practices of 6 of the major high-tech companies, which include Google and Apple. Specifically, the investigation was aimed at determining whether these companies kept employees' pay at artificially low levels by agreeing not to solicit each other's employees in violation of the Sherman Antitrust Act. An agreement was reached in 2010 between the companies and the Justice Department that they would not solicit a competitor's employees for 5 years.
So the companies reached an agreement. They did what the Department of Justice wanted. Why are they being sued? What's the twist in the story?
Well, after the agreement, several employees filed lawsuits against the tech companies, and they argued in those suits that the companies had conspired to fix and restrict the pay of their employees by entering into this no solicitation agreement with each other. A couple of the companies went ahead and settled. But the number of the plaintiffs involved in this is now estimated to be over 64,000. So recently, a U.S. district judge certified and combined many of these lawsuits into a large class action.
How does class action status change the nature of the lawsuit?
Well, the judge found what she called a considerable, compelling common proof that the companies had participated in antitrust behavior by agreeing not to attempt to hire each other's employees. With class action status, it's now easier for plaintiffs to win compensation. The status also puts pressure on the remaining defendant companies to agree to a settlement with their former employees, just as the other companies did. In a recent court filing, the 4 remaining companies claimed that they never had an agreement and that the lawsuit should not receive class action status because they've always paid their workers well.
Aaron, what's the bottom line when it comes to this lawsuit?
Well, a trial date's been set for May the 24th of next year. The outcome of this suit may impact how large corporations seek out and retain their employees.